Hello, my name is Andrea Bryson. I am a social worker and more importantly, I've worked with about 6,000 survivors over the last 2 decades who've taught me everything I know. And I'm here to talk about family violence and how we screen for it. Before I start, I'd like to express my immense gratitude to the good folks at Community Legal Education Association in Manitoba who are hosting this video for legal professionals. I'd also like to share my deep appreciation for my daughter, Andrea Bryson, who is being called to the bar. She helped with some of the research for the slides, and she made this look as nice as it does. I'm recording this on the lands of the Musqueam, the Squamish, and the Tsleil-Waututh Nations, what you may better understand as Vancouver. This is unceded and stolen territory, and it is through the theft of lands, the belief that Indigenous people were lesser than settlers, that have brought us to a time where 67% of Indigenous women experience intimate partner violence. Structural violence will lead to individual violence, and we cannot treat land claims, land back, missing and murdered Indigenous women and girls, and domestic violence as distinct topics. They are woven like cedar hats and baskets that my host nations have made for time immemorial. So I ask you to reflect on what it means to be considering family violence on lands that we are currently stealing. As Riel Dupuis-Rossi says, we are living in an ongoing attempted genocide. Nothing in this video is legal advice. I'm not a lawyer. I can't give legal advice. Please contact your local bar association or law society to seek out a lawyer to assist you if you are seeking advice. Why do we use terms like gender-based violence or violence against women? Those words get used a lot. It's designed to help us think about who's impacted by violence. But I think we need to finish the sentence. When we say violence against women, we're usually ending the phrase with the words by men. We also know that violence is not just limited to women. We know that two-spirit, trans, non-binary, and gender-diverse folks are also at greater risk of violence. And that's because women, two-spirit folks, trans, non-binary, and gender-diverse people are what can be understood as target and oppressed genders. This isn't just in relationships, but in our broader society. Working women earn less than men, which also leads to more women opting out of work to engage in caregiving responsibilities. Data on trans and gender-diverse people show that gendered inequities are not evenly shared. Gender-diverse communities, especially non-binary people and trans women, face higher rates of poverty, more barriers to employment, and more barriers to education. There's persistent earnings gaps even after accounting for age, education, and work patterns. These disparities remind us that gender-based violence and inequity operate across all targeted genders, not just women, and that social and economic structures continue to produce risk and vulnerability for trans, non-binary, and gender-diverse people. Economic inequality often creates economic dependence, which can trap people in abusive situations. And this may be part of the reason why 44% of ever-partnered heterosexual women report experiencing intimate partner violence. It also explains why in 2019, only 20% of women experiencing intimate partner violence reported it to police. Of note, in research on maternal health, about 6 to 10% of pregnant people in Canada experienced abuse. This shows a striking increase of risk at a time when a pregnant person is going to be most dependent on their spouse, but also a time when an abusive spouse may not be the biggest priority to the pregnant person who's experiencing abuse. And abuse can be deadly. About 2/3 of all women and girls who were killed by an intimate partner. And this ties into that notion that if you leave, it will get better. And that's not always true, as those killed by an intimate partner, 15% were former spouses. When we talk about gender-based violence, we also want to look at who perpetrates intimate partner violence. In 2019, Statistics Canada reported that virtually all women who were sexually assaulted said that a man was a perpetrator, and 85% of same-sex victims of intimate partner homicide are men. So where we see this sort of men-on-men violence, men like Michael Kaufman and Jackson Katz and other men who do anti-violence work call this the triad of violence. That violence against women is equivalent to violence by men against other men, which is equivalent to violence against men against themselves. These folks talk about how suicide, self-harm, alcoholism, substance misuse, all these things that put men in higher risk categories are part of this triad that Kaufman created. And this triad informs the analysis of what now gets called toxic masculinity. It's also the reality of who commits harms in our society. Generally, men are perpetrators in 83% of all cases where women are the victim, but also in 76% of crimes generally. We've been talking about violence from this really sort of gender essentialist construct, which is important, but it really only scratches the surface. When we look at people with intersecting oppressions, they're at even greater risk. In the 2018 survey of safety in public and private spaces through Women and Gender Equality Canada, they found that 61% of Indigenous women experienced intimate partner violence in their lifetime, and 67% of lesbian, gay, and bisexual women experienced intimate partner violence. They also found that 55% of women with disabilities experienced intimate partner violence. We can compare that to the 44% of ever-partnered heterosexual women who've experienced abuse a couple of slides ago. This is 20% higher in some of these situations. About 65% of women with cognitive health disabilities and 68% of women with mental health disabilities experienced intimate partner violence. Having worked with people with FASD, ongoing anxiety or depression, and other serious mental health issues like schizophrenia, it's been my experience that they're specifically targeted by partners who want to have control over them. In these situations, partners can maintain control by saying things like, "No one will believe you, you're crazy," and other ways of gaslighting or manipulating survivors, because it's easier to do with people with cognitive impairments or mental health disabilities who are used to not being listened to or believed in our society. And this is why we may see slightly lower but still very high rates for women with sensory or physical disabilities. Women with sensory disabilities, like a white cane user, experience intimate partner violence at 51%, so over half. Those with physical disabilities, for instance mobility issues or an inability to use a limb, experience intimate partner violence at about 53%. I once had a client who was an electric chair user and had a pretty significant health need that required ongoing help, and her partner would deliberately leave her without care at times to punish her. He would assault her as well, and when she started to speak out about the abuse, her own mother said, "Well, you're really just lucky to have him." She was asked by other friends and family members, maybe he needs to blow off steam, or she was overreacting because it's a lot of work to care for her. When we look at seniors, seniors as a group are targeted for abuse, not just by intimate partners, but also by children, community members, and neighbors. We can see how much seniors are targeted by scammers in our society, but that's not borne out equally amongst genders. 58% of seniors experiencing abuse are women, and if it's family-related homicide, about 62% of them are women. When we consider intersecting oppressions, there are also ways that we keep people on the margins of our society. Structurally speaking, women in remote communities simply just have less access to resources. They live in communities where everybody knows them, where everybody knows their spouse, where if there's a safe home or women's shelter, everyone knows where it is. They may not even have a regular officer who attends in the community. So women in remote communities are 4 times more likely to experience abuse compared to other more accessible areas. In Canada, I think we consider ourselves a pretty progressive country. However, 67% of sexual minority women still experience intimate partner violence, and 54% of sexual minority men. In both articles by StatsCan, they point out that the gender of the perpetrator is not declared or is unknown, and that partners who perpetrate harm can be from any gender. That's their disclaimer. According to Eagle 2024, they reported that 64.9% of all trans participants in their research and 60% of all trans women participants in 2 research projects experienced intimate partner violence. And this is a really dated stat now. I wish I had updated stats. I spent hours looking for updated stats. But when we talk about precariously statused people who experience abuse, there's really no data out there. And that's because it's a hidden group. There was research done on people with precarious status who had children who could not leave Canada due to family law. Immigration status said that they couldn't stay permanently, but family law said they couldn't take their kids with them. Of those researched in this tiny report, 100% reported some form of intimate partner violence by their spouse. Now again, it's a very, very small research study, less than 20. But I think it shows how hard it is to get numbers for those who are most precarious and those that have some of the highest risk. I wanted to provide my citations in case people want to look at any of my numbers more in depth. It's important that we language our worlds for our clients. We need to understand that people who are most targeted and oppressed may experience abuse, but it's not just in family law. It happens in many ways. So we need to be really specific for clients that belong to the family law system and to language them in. I think it's really important for us to have broad language that permeates all the ways that our clients can experience harm by another person. We often try to conflate words like abuse, family violence, intimate partner violence, and gender-based violence, but those aren't the same thing, and the differences are really important. One of the reasons I really like using the definition of family violence under the Act is that I can still label the other things that have happened to my clients as abuse and have compassion towards that abuse and still work towards solutions that resolve their issues. Those solutions may or may not be covered under the Act, but instead of saying, oh, that's not family violence, maybe my client has been publicly embarrassed by their partner, or their partner was jealous of them. And combined, there may be some coercion there, but it's probably a hard sell to get protective orders or related remedies. Being able to say what happened to you is not okay is important in our practice. So abuse is this big box. It's any kind of violence against another living being. Calling people names, kicking a puppy, harassing a barista, those are all abuse. The next box we have is at the left, gender-based violence. Gender-based violence is when we do something against another person because of their gender. This is generally violence against women, trans, non-binary, two-spirit, and gender non-conforming people. This is when a server is harassed because she's a woman. It's when a guy calls his wife names because she's his wife. It's violence against trans folks because they're trans. Or when a son is given more family resources over a daughter because she's a girl. Now we go to the box on the right-hand side, intimate partner violence, or what we might also sometimes call domestic violence. This is violence within a relationship. A lot of the time it is gender-based, but it doesn't have to be. And it also doesn't have to be a long-term relationship. This could be dating violence. It could be even violence on a first date. Regardless, it's still abuse, and much of it fits within gender-based violence, and much of it fits within family violence. You'll note that there's a lot of overlap with gender-based violence and intimate partner violence that also isn't in the oval of family violence. So these might be dating relationships. They may be people in relationships that are not spouses under the Act or family members under the Act. And then finally, we have this oval in the center. This is family violence. We can see that it has some gender-based violence, so that might be family violence towards a daughter, towards a spouse based on their gender. There are some areas that are both gender-based violence and intimate partner violence, which might be family violence towards a spouse that is from a targeted and oppressed gender. We can also see that there are some aspects of family violence that are neither gender-based violence or intimate partner violence. This can include violence towards sons and male partners, and depending on your territorial or provincial family law legislation, it could include companion animals, just as it does with British Columbia. Family violence is what the Divorce Act says. It's family violence against a person who is a family member under the legislation. So it won't cover the barista getting harassed, or the person being hit by a guy they were friends with, or the person who intentionally embarrasses your child or client in public. But it does cover more than just intimate partner violence because it includes violence against a child, including gender-based violence against a child. These distinctions are important because having shared language is extremely important. It also means that we get to be flexible in responding to clients whose disclosures of abuse, gender-based violence, or intimate partner violence that fall outside the realm of the violence will still feel heard by us. And this is important because research in California found that when exploring satisfaction of people seeking protection orders, it was not whether or not they got the protection order that correlated with satisfaction. It was whether or not they felt heard. When we say what happened to you is not okay, there doesn't have to be a legal remedy for their experience to be valid. I'd like to take a moment to talk about conventional screening tools. We use a lot of terms interchangeably. Risk assessment, safety planning tools, screening tools, all of these are different ways of talking to people who may or may not have experienced intimate partner violence or abuse. You'll note that I did not say family violence. The role of risk assessments is to assess things like lethality, or how likely is it that your client may face serious physical harm. We don't assess the risk of things like litigation harassment, ongoing emotional terrorism, or the other incredibly harmful ways that the legal system allows survivors to be abused by their ex-partners. I've worked with many survivors where the impact of the ongoing onslaught of harm has caused serious physical health issues, serious mental health issues, and even shortened lifespans. So a risk assessment is a very important tool, but also a very narrow tool. The good folks at Barbara Schleifer Clinic in Ontario have developed a risk assessment tool that is probably my favorite. And so if you are concerned about the physical risk to a client, this is a good option. Safety planning tools don't screen for family violence. They're there to help prevent further abuse from happening. They assess areas of risk that a client might face and provide suggested ways of responding to minimize or mitigate the harm. And then lastly, there are screening tools for various types of intimate partner violence or abuse. And again, you'll note, I didn't say family violence. To the best of my knowledge, there is no questionnaire that exists that accurately gathers information about family violence under the Divorce Act or any of the other related provincial or territorial acts. But we're going to dig a little bit deeper. The good people at Luke's Place and Justice Canada did research on screening tools and put together a report called What You Don't Know Can Hurt You: The Importance of Family Violence Screening Tools for Family Law Practitioners. In their report, they evaluated 86 screening tools. In there, they found that there were 49 question categories and that the 5 most common themes were physical abuse, fear of a partner, threats of harm, sexual abuse, and emotional abuse. At first glance, that's kind of what I would expect to see in a screening tool, to explore at least these 5 areas. I think that seems reasonable. It's not the 9 areas covered under the legislation, but maybe it comes close. Let's take a look at the data. So only about 80% of the tools asked about physical abuse. So 17 didn't ask a question like, has your partner ever hit or hurt you? Which I think is really surprising because physical abuse is one of the most commonly understood forms of family violence. So 20% of tools already missed that. Only 65% of tools, so not quite 2/3, ask about a fear of a partner, which is upsetting because a person's fear of violence is actually the greatest predictor of future violence. That's one of the #1 questions asked in most risk assessment tools. About 59% of tools asked if there were threats, which again feels quite low. It's a bit more than half. This is also an incredibly common question to ask on risk assessments as it's another key indicator of future violence. Now, we're still in the top 5 commonly most screened for topics, but only 49% asked if there is a history or risk of sexual assault, which feels really frustrating because we know that that's one of the most common forms of intimate partner violence. And of course, the most common form of family violence is emotional abuse. And again, 45% asked a question. So less than half asked about emotional abuse. So many tools are missing some real opportunities to catch the very common forms of family violence. But then the bigger issue to me are some of the categories missed, like financial and economic abuse, which is an incredibly common form of family violence that I've seen in my work, and very few tools capture that. When we talk about newcomers and migrants, people with precarious immigration status being threatened, that's very common for newcomers and migrants to experience. But I would say anecdotally 90% of those that I worked with precarious status had this threatened against them. But only 1 tool asked about threats to immigration status. And then about 60% of the tools required a follow-up screening, but that was usually a risk assessment. But perhaps there are some really great tools that the data isn't appropriately conveying. There was 1 tool identified as the most comprehensive, and that's the Mediator's Assessment of Safety Issues and Concerns, or MASIC for short. This was identified as the most in-depth screening tool by Luke's Place in its research, and it's 5 pages long, and it has 51 yes/no questions. And if a client says yes, they indicate frequency. But there are some issues I have with this tool, so I wanted to explore this comprehensive tool with you. The first issue I have with the MASIC tool is not a problem with the MASIC tool at all. It's a problem with practice. So many of my clients were given forms just like this when they were filling out their intake forms, usually even before meeting the lawyer the first time. So we'll see a form attached to a stack of documents, maybe like a blank financial statement for the client to fill out that has a whole bunch of yes/no questions. The problem with having clients fill this out without having a relational conversation is that they may not be forthcoming, and then they have to walk back lying to someone, especially a lawyer. But now nobody here is going to do that. So you may be using a tool like this with clients, and the struggle of going through this tool is the counting billable hours, and that can be a struggle for lawyers and it can be a struggle for clients. A budget-conscious client may say no to questions just to avoid discussions they don't think are important to their issue. And I have seen some lawyers appear reluctant to go too far off script, and so the focus is on getting this tool done so we can move to the next thing. The other issue I have is that the scaling for time is very weird because, frankly, it doesn't matter, but it triggers a bias. There's a belief that something more recent is worse, and that's not always true. I've had many clients tell me, oh, there was just one incident, but it happened years ago. And the reason that it happened years ago is not because their partner is no longer abusive, but because my client has made sure that he never gets that angry again. That doesn't make the situation safer. It means that my client is extremely good at safety planning, so good that they don't even realize they're doing it. The other problem with these questions is that they're doing what I think of as compounding questions. If you say no, the next question is a variation of the previous question, but worse. So it's hard to say yes to the second question. It means you have to backtrack and change what you said, maybe even feel like you have to explain yourself. This also makes the question sound #very serious, and that's generally not the language that people equate with their own situations. As an analogy, and I'm going to talk about serious healthcare issues here, but we often hear about people who are diagnosed with late-stage cancer or other late-stage serious illnesses. People will say things like, well, I thought it was a cold or allergies or a food intolerance, but it was actually much more serious. But they minimized and they downplayed the early symptoms because it didn't feel serious. I personally had anaphylaxis once, and I thought my body was going to blow up like a pufferfish, and it didn't. So it took like an hour for the swelling to really set in. But I had believed that it wasn't that serious. And this is because of a thing called normalization bias. And it affects about 70% of people, even in major catastrophes. But our brains don't recognize that we're in danger because we're looking for obvious clues that we are in danger. And you can look up normalization bias because it's fascinating. But what it means is people don't associate their experiences to these very serious questions that are being asked of them. A little further down the tool, we see another set of questions, but before we get to the questions, we have a phrase that we need to tell the client. We have to tell our clients, I want to remind you that all my questions concern things that name may have done during a conflict, disagreement, or fight, or in anger to scare or hurt you. So we're putting doubt into people's minds about what has happened. They may be thinking, well, I don't know if I remember feeling scared or hurt, or he hurt me, but he didn't mean it, or it wasn't that serious. I don't want my clients to have doubt. If it isn't that serious, if it doesn't rise to the need of a protective order, that's okay. Let's uncover that together. First, I want to get the information from them. I want to know every incident where my client's partner ever kicked or stomped on my client, no matter the reason. They ask you about if they burnt you with something. I want to know about that. I can think of a client where a guy was at the park and he flicked a cigarette at her and was laughing with his buddies about it. That would get missed in this screening. I can't think of an example of my client feeling followed or spied that I wouldn't want to know about, even if my client didn't feel frightened or harassed. This all seems pretty serious. I want to know about all of it and then decide if it's legally relevant. Or if it's really nothing, we can move on together. More importantly, though, some of their definitions aren't really equivalent to the definitions of family violence under the Divorce Act or probably under your Prevention Law Act. In fact, questions 23 to 31 on this slide are all the questions on physical abuse, and the family violence definition is much more expansive than this. And this is what brings me to the last part of the MASIC tool that I'm going to review with you. These are all the types of domestic violence considered by the screening tool: psychological abuse, coercive control, threats of severe violence, but not threats of violence generally, physical violence, again, only those specific types in the question from the last slide, sexual violence, and stalking. But let's compare that to the actual definition of family violence under the Divorce Act. So this is a section pulled from the Divorce Act. Any conduct, whether or not the conduct constitutes a criminal offense by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes the other family member to fear for their own safety or that of another person. That's not necessarily a threat of severe violence as laid out by the MASIC tool. and in the case of a child, direct or indirect exposure to such conduct. I didn't see anything about kids in the MASIC tool. The only question is about child abuse or neglect. However, it indicates that there should be a warning about involving what is often called Child Protective Services, which is likely to elicit a no from any survivors if you say, hey, were your kids abused and neglected? I'm going to call the state if they are. That's not going to generate forthcoming responses. The tool asks about severe forms of physical abuse, but doesn't ask questions about forced confinement under the Act. And while it talks about sexual abuse, it lacks the breadth of how the law could consider sexual abuse under the Divorce Act. The threats of severe violence include threats to kill and cause bodily harm, which is considered under the Act. It asks about stalking, but not harassment. There are no questions about failure to provide the necessities of life. The MASIC tool does ask some questions about psychological abuse, but not financial abuse. There were no questions about threats to harm an animal or damage property, or if the person has harmed an animal or damaged property. So using the most comprehensive tool may give us a false sense of security that we did an appropriate screen for family violence. Even though it asks about 7 types of violence, and it catches 7 parts of the definition, it still misses 8 critical parts of that definition of family violence. And that's why I'm making this video. Instead of looking for the right questions, we want to be looking for the right conditions for disclosure to happen. We want to encourage disclosure, and to do this, we need to think about how clients are navigating their feelings while we're talking about screening. They might be asking themselves stuff like, do I want to talk about this right now? Or how much is it going to cost me if I start crying? Or do I feel comfortable with the person in front of me? They are thinking about their safety. Like I mentioned in the MASIC tool, a lot of survivors with children are very nervous at telling people about abuse because they worry that the state will become involved. They worry about confidentiality, and confidentiality means a lot of different things. They worry that their ex will find out that they told someone and then it's going to be very unsafe. They might be worried that you're going to tell the judge what they told you without their consent. The most safe for them a lot of the time is to not say anything in order to avoid saying the wrong thing. When they lose control of their information, it can be very scary. They may also be afraid that they're not going to get help. A lot of people in services tell domestic violence survivors that their situations are too complicated or that their case is beyond their capacity. They can't have you also tell them that you won't help them. They're also considering if you're going to believe them. It's a terrible thing to not be believed by people that are supposed to be in your corner. When talking about sexual assault, 93% of those who didn't report to police did so because they feared they wouldn't be believed. I've had a not insignificant number of clients ask me about friends of theirs. One survivor in particular said, my best friend is a guy and he told me that his wife is crazy. She wasn't crazy, was she? And I told her, I don't know them, but in my experience, statistically speaking, she's probably not. Survivors know how charismatic their ex is. In fact, they often believe him to be more charismatic than he may actually be, but it's terrifying to them. So many survivors need this attended to in some small ways to build trust. So why are we screening for family violence? The actual purpose of screening for family violence is because we want to know about the client's situation. We need to learn about their situation so we know what remedies are available under the law to fix it. We want to gather information about this situation to assess what evidence might be available that we can ask the client for. And more often than not, the evidence is going to go into an affidavit or what the client will say on the stand. So we need clients to tell us about their situations clearly. I know that if clients are trusted to keep themselves safe and provided with support to disclose, they will. I was the front line of a women's resource center for years, and I spoke to hundreds of clients every year. And almost 1 in 5 did not disclose family violence when seeking services, but within about 20 minutes of a first phone call, I could get the client to disclose family violence. And that's because I would tap into their knowledge and attend to their concerns before I ever started asking them a question. Two-spirit, women, lesbian, gay, bisexual, transgender, non-binary, and gender diverse folks are safety planning their whole lives. It's as natural as breathing air, drinking water, and this is especially true for folks who are Indigenous, racialized, disabled, or belong to any other targeted and oppressed groups. Our clients know what safety is, they know what safety is not, and that instinct is finely tuned, and they don't even realize it's happening. Conversely, they're also told all the time, in all sorts of ways, that they're not going to be believed. They're told that they misunderstood the person who was abusing or harming them. They're told that they should take whatever behavior as a compliment, or that they're lucky to have them, or they're told they need to loosen up, take it as a joke, or that they're at fault for the abuse against them. So that might dampen the voices of those finely tuned senses. So it's important that we see everyone as people who are keeping themselves safe and alive without even knowing it. We need to see them as people who have deeply internalized messages about reasons to downplay, diminish, or deny the abuse. And the worst part is that instinct to downplay, diminish, or deny the abuse is often done as a strategy to keep themselves safe and alive, because then they don't have to worry about disclosure. So we need to attend to both parts of them, the one that's keeping them safe and the one that's keeping them quiet. The premise I start with in any conversation about family violence is that 44% of ever-partnered heterosexual women experience intimate partner violence, and that rate is much higher for two-spirit, trans, non-binary, and sexual minority folks. But I also know that 40% of marriages end in divorce in Canada. So as far as a Venn diagram goes, it may not be a circle, but there is a lot of overlap. So when I screen, I'm not looking for a presence of family violence. I'm looking for proof that family violence does not exist in the relationship. And we all know it's very hard to prove a negative. So our work is to speak in a way that affirms all the ways that clients may keep themselves safe, but also mitigates that voice to keep them quiet. What I've found is that the best way to get clients to talk to us is to find diverse ways of helping them to have more language to describe abuse. By doing that, we belong them into a definition of family violence that's not rooted in a hierarchy of abuse. It doesn't have a definition that's there to only catch the worst of the worst cases. It's there for everyone who may have been impacted by family violence. My 3 key tools is education, vocabulary, and observation. Education is talking openly about what constitutes family violence. Saying things like, did you know that the law says that family violence is physical abuse, but also includes all these other forms of violence? I love to give vocabulary, saying things like, have you heard the term gaslighting? When you say that, it reminds me of that term. Or, you said that he removed the condom during intercourse without your permission. Have you heard the term stealthing? Because that's what that is. Or, you told me that he was grabbing your wrist during an argument. That's impacting your personal autonomy and integrity. It's stopping you from being able to leave. And that counts as physical abuse under the law. We can also use observation. We can talk out loud about ways they keep themselves safe. I often use terms like, it sounds like you are managing his mood, or walking on eggshells, but also how survivors cope with family violence. Like saying, a lot of survivors return because they can manage him better by making the food appear on the table, or some survivors tell me that they could keep their kids safer in the relationship. Sometimes the observation is just me wondering. I say things like, I wonder if that maybe happened because you were trying to protect yourself, which ties into some of my linguistic tools. I have key strategies I use in my linguistic presentation. The first one is I'm oblivious. I know nothing about their situation, but I'm curious and I have wonder. I use phrases like, I've only known you for a couple of days or a couple of weeks or a couple of months. I say things like, I don't know your ex, I've never met your ex, or I've only seen your ex in court. But then it leaves me room to ask big questions because I've already said I don't know anything. Now my client has complete control to be able to decide if they trust me. They have wide parameters and easy exits to the discussion. They can say things like, yeah, we haven't known each other long and he's not like that. But this stops them from feeling like they have to defend the person who's been abusing them because I ask a question too directly. I like to show that I'm trusting of survivors. The main way I do that is I use examples. I say things like, my client told me about a time when her ex did this and that was abusive and I really wanted to help her. Now the client knows that I trust survivors to tell the truth. It shows that I have a broad range of knowledge about domestic violence and abuse, and it shows that I listen to survivors because that's one of the big concerns they have. Will I believe them? And then I witness their resistance. I witness their resilience, and I witness their amazingness. You may be the very first person to do so in a long time. Clients have told me about horrific beatings without tears, but when I point out that they're an amazing mom for keeping their kids safe, they start sobbing. When someone sees you the way you want to be seen, in a way that corresponds with what you're trying to do, it creates intimacy in the relationship. You may be the first person to see that they were acting protectively of their children by returning to the abuse, or that their substance use probably helped them to cope with the violence. If you're interested in this concept, look into Small Acts of Everyday Resistance to Violence and Other Forms of Oppression, which is a paper by Alan Wade, who's a counselor who specializes in domestic violence. All domestic violence survivors are inherently resourceful and resilient, and we can tap into that. We want to give power to survivors when we're working with them. So how do you clarify your role in client-centered ways? We can do this by framing the client as the expert of their own experience. I am here to take your instruction and I'm going to try and move your case forward. I'm not going to do anything without your say so, without your instruction. This is how I do my practice. We can offer space and create space for decision making. We need to be transparent about deadlines and when things are due, but we can offer flexibility and choice where possible. We have to file this reply by Friday. However, we can amend it later. What would it look like for us to submit this reply now and see how you feel next week or next month and amend then? We can also recognize other solutions. We don't want to treat everything like a nail if all we have is a hammer. Not all issues are legal problems, but we can still provide support. We can help clients to choose non-legal or safety-based paths. We can do so by helping them to connect with other services or other resources and to tell them that we care about them and want them to get the right services for them. We can also make space for safety-driven choices. We can acknowledge our legal obligations, but we can also acknowledge our human concerns. As a lawyer, I need to tell you that you need to do X, Y, and Z. But as somebody who cares about you, I want you to be safe. So I'm going to connect you to this resource. And then if you want to address A, B, or C, let me know, and I'm going to help support you with that. Until now, we've been focusing on relationship building and rapport building. So now we're getting ready to probe for violence, and we want to be prepared with probing questions that we can use as needed. I like to talk to everyone about family violence. Would it be okay if I asked you a few questions? You said something interesting. Could I ask you more questions about this? I know that this might be a difficult topic to talk about, but I'm wondering if we could discuss one piece at a time. I know we've talked about a lot of sensitive stuff today, but I have some follow-up questions. Would you like to talk about these now or the next time we meet? I know you said that there's no abuse, but I know we need to screen for things that might be on the spectrum. Would that be okay with you? You can hear in all of these probes that I'm asking a question, and this is incredibly intentional. We always want to give people an opportunity to not talk about family violence. It may not be the right time, the right day, or the right situation. So now that we've started to have the relationship, now that we've probed and they've said yes, how do we actually screen? Almost all the provinces and territories have their own legislation that oversees family breakdown, and they all have a definition of family violence. I'm going to encourage you to connect with your colleagues or your local services for domestic violence survivors and ask them about your own legislation and examples that they can provide. Going forward, though, I'm going to use the Divorce Act. We're going to use the Divorce Act definition of family violence to explain how family violence works to clients. So I'm going to walk you through the definition piece by piece with examples. So family violence means any conduct, whether or not the conduct constitutes a criminal offense. So that doesn't have to be charges or even police called for it to matter. It doesn't even have to be something that police could charge for. And it's done by a family member towards another family member. And it's something that is violent or threatening or that constitutes a pattern of coercive and controlling behavior. This sounds really serious. But what you need to know is that it can be a one-time event or it can be a number of events. There can even be a pattern. For instance, I've heard a client say that whenever they ask about money, their partner stomps around the house, so they learn not to ask about money. In other situations, I've heard of a person who uses abuse against my client, and they would tell my client how stupid they were all the time. If they wanted to go back to school, they were stupid. If they thought their kid should attend a better school, it was stupid. All designed to make my clients second guess themselves. We can also see this in a single incident. I've heard from many survivors that there was one incident many years ago, but when I asked, they say that it was because they never wanted to make him that angry again. So what ends up happening is under the Act, it says that it causes the other family member to fear for their own safety or for their safety of another person. So this doesn't have to be physical safety. You can be afraid that your kid is going to face any of these described forms of coercive and controlling behavior, for instance. And when we're talking about children, that can be direct or indirect exposure to such conduct. So that might be your kid hearing an argument down the hallway, or if you've ever had that feeling when you walk into a room where you know people were arguing before you walk in, the term is they say you could cut the tension with a knife. That's a form of family violence under the law because your kid is feeling that tension. When we talk about specifics, there are 9 categories that's outlined in the Divorce Act. The first one is physical abuse, which includes forced confinement, but excludes the use of reasonable force to protect oneself or another person. So this is anything that affects your bodily autonomy or integrity. So we tend to think of physical abuse as that hitting, kicking, pushing stuff, and that's definitely physical abuse. But what we hear more commonly is grabbing an arm or a shoulder so you can't leave an argument, or having to lock yourself in the bathroom because he's in a really bad mood. There's sexual abuse, and this can be a sensitive one. We often think of this as forced intercourse, but that's not the most common experience. This is about sexual autonomy and integrity. Consent is done with freedom and enthusiastically. What survivors sometimes tell me is that they agreed just to get him to leave them alone, or they're doing it because they're badgered into it. And that's not free and enthusiastic. The next part is threats to kill or cause bodily harm to a person. And that can be specific threats like I'll kill you. But it's also threats like I'll kill myself. It can also be non-specific threats that you know indicate a concern for your physical safety, like you'll be sorry. Harassment, including stalking. Harassment is any communication that's unwanted. We often think of the phone being blown up with where are you, or who are you with, or why aren't you home? But I've also heard it to describe following a person through the house after they said they need some space and don't want to talk right now. And they chase them through the house saying, we need to talk about this right now. For stalking, we often think of a car outside the home, and that is stalking. But more commonly, we hear of tech-facilitated stalking, or what's called social engineering. Tech-facilitated stalking can be using things like AirTags in a purse or a trunk to monitor whereabouts. It can be making fake social media accounts to gather information about you. Social engineering is talking to other people to gather information they don't know that they're not supposed to share, like pretending to be a delivery driver, calling your work to find out your hours this week, or calling mutual friends to find out what you're up to. The next one is the failure to provide the necessities of life. This might be what we understand as neglect. And when we think of neglect, we often think of children not having food in the cupboards, or not watching them and leaving them at risk. In relationships, that can be withholding healthcare, clothing, tampons and pads, and the necessities for daily basic living. The next one is psychological abuse, which is often thought of as name calling and criticism, which it is, but it can also be nonverbal, like silent treatment, driving the car really fast or dangerously while angry. I've heard it sometimes as describing as walking while angry, like they're looking for food in the kitchen and everything is slamming, or things are too still and too silent, like you're waiting for the shoe to drop. The next one is financial abuse. This is often thought of as withholding information about family money or the money itself from a spouse, and that's incredibly common. We can think of it as much broader than that. For instance, forcing a partner to incur debt or a credit card they don't want to get, spending family money so that the rest of the family suffers. This is very common with abusers who also have gambling addictions. In one situation I helped out with, the partner just never found time in 2 years in a small town to stop at the bank to get his wife a debit card. The next one is threats to kill or harm an animal or damage property, and the killing or harming of an animal or the damaging of property. This is often described as like the partner punching the wall. Whether or not they damaged the wall isn't important. It's the fact that they were suggesting they would. This can be suggesting a pet might disappear. One person I was with was on the phone and they threatened to smash their hamster's cage if she didn't come back home. This is when important documents go missing or your favorite cup is broken because they did the dishes for the first time in 7 years. This happened to a client of mine because she didn't do dishes while sick with COVID. So now that we've understand how the Divorce Act can be used to screen, we're going to talk about how that actually works on the ground. The first thing to know is that we're going to walk through that definition of family violence. That is the tool, and we always have access to it. There's no paid subscription or app required. The second thing we're going to do is inform clients about what we're doing, and we're going to get consent at each step. The next thing we're going to do is tap into the part of our client that helps keep them safe, and we're going to silence the haters by providing information about family violence and giving common examples. This is called evoking common experience. This is from a book by Stephen Lumet. So we can provide singular examples, provide ranges, or give points of triangulation to understand if our clients might fit into that category. We're going to use some of these tools when we have the opportunity. Things like education, vocabulary, observing. We're going to talk about how they keep themselves safe, obliviousness. We're going to show that we trust survivors, and we're going to think about that witnessing resistance and resilience. At every step of the screening, we're going to ensure ongoing consent. This is the first time they've been asked about consent probably in a very long time. We are going to keep it an authentic ask. They can say no, and we will 100% respect that and thank them for saying no. Then we're going to ensure that they understand each part of the definition. As we go through each part, we're going to ask if that resonates for them and their situation. I'm eager to welcome Kala to this presentation. She's going to play the role of my fake client. Before we go into the mock screening, and for clarity, I like all my mock screenings to reflect a reality. So there's no script, there's no rehearsal. There was a bit of a conversation before this. So Kala, what's your client's name and what's the opposing party's name?
My name is Christine and the opposing party is Doug.
All right, and how long have you and Doug been together?
We've been together for about 8 years.
Wow, and how long have you and Doug been separated for?
About 6 months.
All right, and are there any children, and if so, how old are they?
There are two, we have 2 children, so one is Sarah, she's 5, and one is Joe, the latest, the youngest, and he's 2.
Wonderful, thank you so much. And now we're going to launch into the screening. Before I get started on the mock screening, I want you to know that I have screened thousands of survivors regarding family violence. So you're not going to sound like me, and I don't want you to sound like me. I want you to sound like you. So you may want to pay attention to the words I use, how I phrase things, how I respond to the client. But it's really important that you find ways to respond and to sound like yourself when you're doing screening. So Christine, thank you so much for meeting with me today. As a part of my practice, when I meet with clients and get to know them, I like to screen for family violence. Would it be okay with you if I talk to you about family violence under the Divorce Act?
Yep.
So what that will look like is I'm going to walk you through the act. I'm going to give you some examples. I'm going to make sure you understand what I'm saying, and then I might ask if it applies in your situation. At this point, I am just doing a screening for family violence. I don't need to necessarily hear all the details of the situation. If there was a situation where there was family violence and we needed to engage in protective measures for you, then I might get more details at that time because we might need to do something like write an affidavit or prepare evidence for court. Does that make sense when I say that? Do you have any questions before I move on to the next piece?
Yep, that makes sense.
Great. So the first thing that you need to know under the Divorce Act is that family violence means any conduct done by a person. So that can be something that is done in the relationship in the normal course of a day. It can be something that happens very suddenly, that's out of character, any conduct that happens. And the Act says it's whether or not the conduct constitutes a criminal offense. So it doesn't have to be something that the police were called for or police charged for. It doesn't even have to be something that the police could even charge for. And it's done by a family member towards another family member under the Act. It's something that is either threat violent. So when we say violent, that's usually like an incident that's really scary, something big that's happening. Threatening is something that makes you, like, it's usually something you heard or saw them where they're trying to make you feel really afraid. Or there's a pattern of coercive and controlling behavior, and that might be harder to point out. And like people say, it's that I've worked with, they'll tell me like, oh, like I can't put my finger on it, but I just know this bad thing would happen. So that's coercive and controlling behavior. And so if one of those 3 things happen and it causes the other family member to fear for their safety for themselves or another person, so they might be like, oh, they're going to hurt me, or I'm really worried that something that has great meaning to me is going to like be destroyed, that's a threat against you. Or another person might be, oh, like I'm afraid for my family back home, or it might be something that I'm afraid for my child. And so it's anything that causes you to have fear for your own safety or that of another person. And then when they talk about children, so any of those things that are violent, threatening, coercive, or controlling at a child is a form of family violence, but also something directed at the other family member. And the child maybe sees it, or it happened down the hallway. Have you ever been in a room where two people have just been arguing and they say like the tension can be cut with a knife?
Yeah.
Yeah, so maybe if your child maybe walked into the room like that. I know that the vast majority of those that I worked with have done everything they can to avoid their child witnessing or walking into that feeling. But a lot of times the people I work with don't have a choice about that because it's something that's being precipitated by the other party. So that's the preamble before we get into the list of the pieces that are covered under the Divorce Act. Before I go into this list of things that are covered by the Divorce Act, do you have any questions for me?
One question I might have, just because I don't know how it works on your end, but like if I need to take breaks, like, or if, if like we can't finish, like it's okay.
Yeah. Okay. You can stop me at any time. Yeah. You know, we're going to be talking about some heavy and sensitive topics. That was what I was just
noticing, and I just wanted to make
Yeah, and at any time you can say, I don't want to talk about this anymore, and we're going to stop the conversation immediately. And the other piece is I don't need to hear any of the details. A simple nod is sufficient. I will mark it down, and then as we maybe work through things later on and we start exploring legal remedies, I might ask you more questions at that time. But yeah, you can stop us at any time. We can take a pause. I can show you where the washroom is, whatever you need.
Yeah, I don't want to be crying in front of you. That's all.
Well, you are welcome to cry in front of me. I got the box of tissues, and so it's all okay.
That's excellent. Okay, yeah.
Okay. So when we, under the Divorce Act, family violence includes, now it's not limited to, it doesn't say this is an exhaustive list of what family violence is, it says include. So there can be other pieces of family violence that are not on this list that may also count as family violence under the Act. Okay? And so the first thing that they say is physical abuse. And I think that's what most of us think about when they talk about physical abuse. And they say forced confinement, which sounds like cages or something like that. And yeah, that hitting, kicking, pushing stuff and you know, being unable to leave, those are definitely physical abuse because they violate your bodily autonomy and integrity in very serious ways. Yeah. But a lot of what people have described to me over the years is maybe like he grabbed my wrist and wouldn't let me leave the argument. Yeah. Or I locked myself in the washroom because I didn't want to be in the argument anymore, or it was just safer to stay in my bedroom than leave the room. And so all of those were affecting my client's bodily autonomy and integrity.
Yeah.
Does that make sense when I say that? Do you have any questions about that?
No.
Okay. And does any of that sort of connect or resonate for you in your relationship?
No, I think with Doug, like I think lots of guys these days, like I think he'd be honestly just too smart to do any of that.
Yeah.
Yeah.
Okay.
Yeah.
I'm really glad to hear that you haven't experienced anything like that. Is it okay if I continue on to the next part of the list?
Yeah.
Okay. So the next one is sexual abuse, and I think this one's a really delicate one. So again, I don't need any details today. So when we talk about sexual abuse, a lot of the time we think of that as like forced intercourse, which of course is sexual abuse. What I hear more commonly though from clients is things that violate what we call free and enthusiastic consent. Have you heard those terms, free and enthusiastic consent? So for instance, I had a client and she was like, well, if I said no, he was just going to bother me all night.
Yeah.
So that's not free. Another client of mine said, well, I said yes. I felt like I had to do it, and so I did it. I got it over with. That's not enthusiastic. And so where we talked about physical abuse being about your bodily autonomy and integrity, sexual abuse is about your sexual autonomy and integrity. Mm-hmm. Does that make sense when I say that? Do you have any questions for me?
No.
Does that resonate or connect for your situation at all?
I think with what you're describing with your, like, when we birthed in the past, I think I can relate to that, but yeah, so like if this was a checklist, I think maybe I'd probably check yes, but like I don't know if I'd really want this in like court pleading, like I don't know, it's just really embarrassing. Yeah.
And nothing's going into a court pleading or anything without your consent.
Yeah.
Okay. And yeah, nothing will happen without your consent, but I'm really grateful that you told me that. And I'm sorry that happened.
It seems like with my friends. It seems like all of us. But, yeah.
Well, just because something is common doesn't make it normal.
Yeah.
Okay. Is it okay if I continue to ask you some questions under the Family Divorce Act?
Yes.
Okay. So the next one is threats to kill or cause bodily harm to any person. So again, that sounds really serious, like I'm going to kill you or, I'm going to hurt you. Those are, of course, threats to kill or threats of bodily harm. But you might also hear things like, you'll be sorry, or other things that make you go like, I don't know what they're going to do, but I'm pretty sure it's pretty scary. It's also to any person. So that could be, you'll be sorry, or I'm going to do this thing, and you might know that it threatens another person. Like, I'm going to tell your boss, or I'm going to go after your mom, or what's going to happen to your family back home. So those can be threats, but it could also be things like, I'm going to hurt myself, or I'm going to kill myself if you don't come home. So it's about threats to kill or cause bodily harm to any person. And so that's one form of family violence under the Divorce Act. Does that make sense when I say that? Do you have any questions about that?
No.
And does that resonate or connect for your situation with Doug?
Yeah, so it does. And that's actually why with the prior question, I was like, I wouldn't want this in the pleadings. He's honestly, the part of the reason all of this is very hard is he's very unhappy about what's, our separation. It's hard to say about your partner, but yeah, he's starting to kill himself several times. I don't think he's serious, but also I won't know until I do, I guess.
No, and that's really upsetting, and I'm really sorry that that's happened. And again, we're not putting anything into pleadings. We're not doing anything.
Yeah, that's why I was worried about him, because his mental health is just really not good.
I get that, and that makes it really hard for you.
And sometimes he says it out of anger. Like,
of course.
Like, I don't know, like he's...
Yeah.
It does seem like he's trying to punish, like... But yeah, it's hard.
And that's part of that conduct. It's any conduct. It's not whether or not they're trying to scare you. It's... Even though... And it's also that coercive and controlling behavior. I think you're changing the way that you talk to him.
Yeah.
In order to stop him from being so...
Oh, yeah, I drop it. Yeah.
Yeah. Yeah. Thank you for sharing that with me, and I'm going to make a note of that as well. The next part under the Divorce Act is, sorry, is it okay if we continue on with the...
Yeah.
Okay. The next one is harassment, including stalking. And so harassment, a lot of times we think of that like after people separate, where, they won't stop calling and stuff like that. But you can have harassment in a relationship as well. I had a client, and, they'd have an argument, and he would chase her through the house. Like, she'd say, I don't want to talk about it. I don't want to argue with you anymore. He would continue. So any communication that's unwanted communication. A lot of people that I work with, my phone was blowing up with texts. He wouldn't stop calling my cell phone while I was out with my friends. I had to keep leaving the bar. I had to keep leaving the restaurant to talk to him. That's all, like, even if you are like picking up the phone, it's still harassment, because you've told them, I want to be alone, or I want you to leave me alone, and they do it anyways. And then stalking, we tend to think of stalking as like the car parked outside the house and watching, and that is, of course, stalking. What we're seeing more commonly is tech-facilitated stalking. Have you heard the term tech-facilitated stalking?
No.
So that might be an app where your GPS is tracking you. A lot of, do you know what an AirTag is, or a Chipolo? So there's a variety. There's Tile. There's a lot of Bluetooth devices, and you drop them in a bag. A lot of people put them on their keys. That's what they're really for, is to make sure you don't lose your keys or your wallet. But abusive partners can sometimes drop it into the trunk of a car, or the purse, or bag, or diaper bag, so that way they can keep tracking. Has anything happened that makes you go, I wonder if I'm being followed, or anything like that?
No, we have like a family app, so like I kind of like knowing where he is when he's with you. Yeah. So like I feel like it's...
Yeah, and that's the thing, when there's consent, right? Like if they're blowing up your phone, you're like, oh, I love getting all these messages from them. That's not harassment.
Yeah.
It's when you said, I'd like to have a little bit of quiet.
Yeah.
The other piece to stalking that we sometimes hear about is social engineering. Have you heard the term social engineering before?
No.
So that's where you try to fool other people into giving you information you're not entitled to. And so that might be creating fake accounts and friending people, pretending to be you, or it might be calling up your work and asking what your hours are, or it might be calling people that maybe aren't familiar with the separation and saying, oh, well, is Christine going to be at this event?
Gotcha.
And so those are all types of social engineering, and it's a way of gathering information or learning about you or getting details, which is what stalking is. It's about gaining access to another person's life that they don't want to grant you access to. Does that make sense when I say that? Okay. And does I know that you mentioned that you have the shared app. When I say that, is there anything that comes up for you where you have a concern?
I think that just on the harassment thing, I don't know what my rights are, because that's also why I'm trying to get legal advice, is I don't know if I'm allowed to say no to this. But he gets really aggressive if I don't. Basically, if the kids are with me and he's not with the kids, he gets really up in arms about it. And so if I don't respond to his text within 10 minutes when the kids are with me only, it's either a wall of text, or it's like, or it's worse, one text. It can sometimes just be one text, but it's quite, call me, and I don't. And then I'll have like it's a really, no matter what, he gets really, really angry. He's followed us to the park, because we obviously have that app. Anyways, I think parents have rights, I guess, but I don't do that. I'd like it if there was more, I don't know. I don't know what I'm allowed to say or do. Like, maybe he has rights to his kids, but it's really embarrassing, actually, in public.
I bet. Yeah. And that's exactly it. When you're in a co-parenting relationship, there needs to be agreements about autonomy and integrity, like bodily autonomy and integrity. What I'm hearing is that you're changing your behavior of how you'd like to parent your children in order to conform to his mood.
Yeah.
And that, to me, sort of gets into that pattern of coercive and controlling behavior, like the way that you describe those texts.
Yeah, I guess I feel like people will be like, he's a caring dad, and I should be lucky to have, because I know most of my friends, their partners don't want anything to do with their kids, whereas he's,
Yeah.
But yeah, he wouldn't have, he's yelled at me in front of my friend, and it's embarrassing for the kids.
Of course.
That one time he showed up at the park. Anyways, but yeah, I don't know. I don't know what the court said. I don't know what any of it. Yeah. But what you were saying made me think maybe. But.
Yeah, and that's really great information. And so what we're going to do is, as we work together, is we'll come up with some legal remedies that will hopefully help maybe change some of those behaviors. We can't force an epiphany, but maybe we can set up parameters around parenting schedules in order to make sure that you have the autonomy you need to parent.
Yeah, and I think if it's not coming from me, he'll be probably a lot more receptive to it, I think.
Yeah. Okay, is it okay if I continue on with the next part?
Yeah.
And so the next part is the failure to provide the necessities of life. And so what we often think about that is like what gets called neglect. Like sometimes we hear about child authorities that go and investigate for like, do you have food in the cupboards and stuff like that. And that is failure to provide necessities of life if you don't have food in the cupboard. But what we often see in relationship breakdown is failure to provide like food, but also things like a number of my clients aren't able to get hygiene for their periods and stuff like that. They're not able to access things like their healthcare needs. There might be restrictions on their medication. There can be sometimes lack of access to their caregiving. Like I've worked with clients. I had a client who was in a motorized wheelchair and needed help with daily living. And so when her partner would get angry, he wouldn't charge her motorized wheelchair. So things like that. So those are all really serious situations, but there can be lots of other ways that might show up more subtly in relationships. Like I had a client and she needed to get food, and so he gave her a bag of change. And so it made it embarrassing for her to access her basic necessities. Does that make sense when I say that? Do you have any questions about that? And does that connect for your situation with Doug?
Honestly, like I'm more of the body of the relationship. Yeah. So I can take care of, everything. Okay. But
well, that's helpful information. We're going to talk about financial abuse in a moment, so I'm going to put a pin in that, if that's okay with you. Would that be okay with you?
100%.
Perfect. So the next one we talk about is psychological abuse, and I think that that's a lot of that sort of name calling, and it's making people sort of feel nervous or afraid in their day-to-day life. It might be belittling comments and stuff like that. Gaslighting, have you heard the term gaslighting before? Yeah, so it's making you think that something, making you doubt your senses. So yeah, like, do you have any questions about that? Is that all making sense so far? Okay, and does that resonate or connect for you?
I think just like with the kind of like park incidents and stuff like that I was talking about earlier, I think maybe, like, because honestly, it's obviously didn't feel great. And when before you were connecting to the term harassment, I was like, yeah, it did feel quite bad. I felt maybe I should look past it for my kids, but yeah, I don't know. I think that he definitely makes me second guess myself. Like, I don't think I'd tolerate it if his conduct came from like my boss or from my friend or something like that. And I feel like he's really good at getting me to look past a lot, because he'll, I should be very lucky that, he cares about our kids, which I am. I'm super grateful he cares. Like, I'm glad he cares. I just think he could be a lot less aggressive towards me when showing up as a father. I don't know why it's,
Yeah, and that's exactly it. And what you said there, like, I hear that you keep saying, I should be lucky, I should be lucky. Mm-hmm. I wonder where you got that message from, right?
Yeah.
And
because my mom doesn't. She does not think I'm like, but so yeah, I hear different things from different,
Yeah, and so, what I'm hearing is that you're not feeling lucky.
Yeah.
And that's the difference there, right?
Yeah.
How you feel matters a lot. And, what I'm hearing is that you are putting up with a lot in order to make sure that your kids have a good relationship with their dad.
Yeah.
And so I think you're doing a really great job as a mom.
Mm-hmm. Thanks.
Do you have any other questions or anything else about psychological abuse?
I think that made sense.
Is it okay if I move on to the next one? So the next one is financial abuse. And so, or also gets called economic abuse.
Mm-hmm.
Financial abuse is, a lot of people sort of think about that as sort of money. Like, they wouldn't let me have access to money. They made me pay all the bills for the household, and his money went to video games. He took out a big truck that we couldn't afford, and so I got stuck paying for all the bills. Sometimes it can be taking out debt or credit in the other party's name without them knowing, or with them knowing, but not really with their free and enthusiastic consent. It's about their financial autonomy and integrity is now being taken away. We might also see, so economic abuse might be impacting their work or their future career. So for instance, I had a client and he was always late to pick up. So that meant she was always late to work. So she got passed over for promotions and raises and often got into trouble from work. Mm-hmm. And it was intentional. And because he could show up on time when it was daycare and he was going to get charged $15 for being 5 minutes late. The other place I saw this was, I had a client, and every time she went to school, and every time she had a test or an exam or a paper, those were the nights that he would always pick a fight with her. And so that's economic abuse because it's impacting her future career. Mm-hmm. Does that make sense when I say that? Do you have any questions about that? Does that resonate or connect for your situation?
Yeah, well, as I mentioned, like, I am kind of I don't know if it's the right term these days, but I make significantly more than him, but and this is actually what kind of led to our separations. As I liked his free willed. I'm kind of like, he's always been boisterous, and he's a Sagittarius, and I'm a Virgo, and so we balance each other out. And he's very, like, I don't want to say in a judgy way, but he's just so irresponsible with money, and I feel like I'm not sure if it's pointed. It feels pointed at times, especially in the past couple of months. But he's just been doing the most, like, so we have a home. It's not worth a lot. But he tore up the entire basement with no plan. I told him, like, as our separation continues, we're going to need to sell the home. Yeah. And it feels like he's, like, deliberately damaging, like, because he was laughing about it. Like, he thought it was super funny, and he doesn't have the funds to cover. He knows I'm going to be on the hook for it. Like, honestly, it's made me question whether I can even separate from him, because I don't even know if our home is sellable. Yeah. Because it's not just the basement. It's also, like, our bathroom has been unfinished because he just, but yeah, he's kind of, there's been a couple of I don't know why, but he somehow dented our car, which was perfectly fine. It's like a 2021 like Prius, like I don't maybe it's just because he's like not doing well psychologically because of all of this, but if he feels particularly reckless with the money right now, and
so that's exactly what we talk about, like that financial control, right? He is deeply impacting your financial autonomy and integrity. He is not asking you or engaging you in decisions about your finances, and that's another form, and that's family violence under the Divorce Act. Thank you again for sharing that. I'm going to make some notes about that for the next part of our working together. Maybe see if there's some stuff that we can do to help.
Yeah, because maybe I should be speaking up more or something, but
Well, the thing, it's about the conduct, right?
Yeah.
The Divorce Act doesn't say, oh, well, you have to take reasonable steps to stop the abuse.
Yeah.
Right? And that's because we know that the vast majority of survivors can't. And what you've told me is that when you try to talk to him about the separation and stuff, he makes some pretty serious threats.
Yeah. No, he would have yelled at me probably, especially because we're not in the park. Yeah. Which is why but I don't know. Yeah. Sometimes I know like lawyers, you're supposed to take reasonable steps to mitigate things, but it sounds like maybe not in this context.
Yeah. Well, and the thing is the reasonable steps you took was to keep you and your kids safe.
Yeah.
And to start taking some steps to separate.
Yeah.
That sounds like the most reasonable steps that you could take.
Yeah, no, they go like catatonic. Like my kids just become so unresponsive.
I'm so sorry to hear that.
Yeah.
But I can see that you're trying to do your very best for them, and that's what matters. Is it okay if I move on to the next piece? So the last part, I'm going to do the two parts together. So it's threats to kill or harm an animal or damage to property, or the killing or harming of an animal or damaging the property. So it's whether the threat of doing the thing or actually doing it. So clients have described to me that he said he didn't know what was going to happen to our pet, and I know that it meant that he was going to get rid of it or even hurt it. I've had many clients report that, like one of my clients' cats was chased until it would run away. Another situation that I hear more commonly is that threat to damaged property or actually damaged property. So that's like hitting the wall with the fist, maybe even putting a hole in the wall. It can be broader than that, though, as well. It can be damaging documents. A lot of passports go missing. Go missing in quotation marks, or coveted clothing, other items that are family heirlooms might go missing or get damaged. Does that make sense when I say that? Do you have any questions about any of that? Does any of that connect for your situation?
I mean, yeah, there's obviously all the renovations he's currently doing. But the other thing is, like, even though I have most of and this is actually something that caused me a little bit of stress, is we have a storage locker. Everything in our family is basically in my name except for that one, except for the storage locker because it was pre-existing before our relationship. They're annoying to move anyways, and it has a bunch of stuff in it, and he is really he does not want us to separate, and so and I can't, since I'm not the account holder, the storage locker people, and it's a dude running it, he's really not reasonable with me. But it looks, Doug just seems to be of the opinion he can just stop paying for it, and there's some family heirlooms in it, and I don't know I don't need, like, I'm sure I could show up and just like try to buy the locker when they're like, I watched a TV show about it, like maybe that's what I talked, like, it's kind of he brings it up a lot that he might just have to stop paying if this divorce costs him everything.
That's really scary.
I don't even know if he's, like, honestly, it's really
No, that's really scary, and I'm really sorry that your heirlooms are trapped in this situation.
Put them there,
And so I think we can work together on some remedies that might help to alleviate that stressor. So that we've gone through the whole of the family violence section of the Divorce Act. Was there anything you wanted us to revisit, or anything that we can do to help you to better understand what family violence is under the Divorce Act?
No, like, more came up than I was kind of anticipate. I'm like, I still don't know if all of it, but that's your job, I guess, is to figure out what.
Yeah, and we will talk together about what remedies might exist and how we might put forward some of the evidence that you have.
And he is a good
yeah,
he's flawed. I think he's anger. I think he's acting out of anger right now.
Yeah. And whatever the reasons are, you deserve to have your integrity and autonomy. And that's what we're going to do. We're not taking away from him to give you autonomy and integrity.
Okay, yeah. I appreciate that.
Anything else you need from me?
Well, that's everything.
All right. And we're going to end the scene. And thank you to Cala for your help with this.
Of course.
So you've screened for family violence. What now? Make sure that you already have our list of resources. I'm encouraging you, as soon as you're done this video, call your local domestic violence shelter and ask them about referrals. Ask them about wait time. Ask them if there's other resources that they know about if a survivor shows up. Do they have any brochures for your desk? I want you to call your local settlement office and ask them about referrals, resources, and who specifically they serve. Ask them if they have brochures for your desk. And you're going to call your local victim services program. You're going to ask who they serve and what other similar programs exist in your community. And again, we're going to ask if they have brochures as well as business cards. You're also going to bookmark their website, and you want to look up your local regional victim services office and ask them to send you business cards or a poster for your office and washroom. Most importantly, I want you to set a calendar reminder to do this at least once a year, but ideally every 4 to 6 months. You're going to develop important relationships by having more frequent calls. It also makes sure that your information remains current. Over the years, my approach to screening for family violence has been taught to hundreds of legal professionals. And over those years, there's been less than a handful of lawyers who've opined that this approach for clarifying the law somehow coaches survivors to make false disclosures. These opinions, however, are rooted in myths and stereotypes of domestic violence. It suggests that survivors will lie if given the chance, and it also assumes that these survivors have an incentive to lie. Legal scholar Jennifer Koshan writes, "The response to this cluster of credibility myths is research indicating that women are often reluctant to raise domestic violence lest their motives be questioned, and that false allegations are much less common than the problem of genuine victims who fail to report abuse." This rebuttal is supported by Canadian statistics and by research that women are frequently told by their lawyers not to raise domestic violence in family law proceedings. Further, Stephen Labette in Modern Trial Advocacy confirms that it is permissible to invoke common experiences. He further says it's good to ask if something similar has occurred to the witness in order to help a witness remember details that might have seemed unimportant when they occurred, while it would be impermissible to prompt a witness to add facts that did not take place. There are other instances where we might invoke common experience to illustrate legal concepts. For example, we might discuss various parenting arrangements or schedules, or provide examples of different types of decisions that parents may need to make in order to help ensure that a client understands the nuances of parenting time and decision-making responsibilities. Interestingly, these areas rarely receive the same scrutiny as issues of family violence, and this is probably because of the widely held myths and stereotypes that women commonly invent claims of violence as a way to influence litigation, despite decades of research that shows that violence tends to be vastly underreported, as Koshan already articulated. Additionally, there is some substantiation that giving those who experience gender-based violence more preparation is better for the legal system overall. For example, legal scholars Jacqueline Whitecroft and Louise Ellison have conducted research on witness preparation and prosecution. Their example appeared to be in a sexual assault case, and they've argued that greater preparation for complainants can assist with higher quality and more accurate evidence in court. Therefore, we must ensure that those who are family violence survivors under the law are belonged into the definition of family violence as laid out in the legislation. This is the role of this framework I use. Research by Dr. Catherine DeVerne, KC, for the Public Legal Education and Information Sectoral Planning found that, aside from eviction, most participants in focus groups, when given a legal scenario, did not identify that their scenario was legal per se, but rather framed them as social, health, housing, or other problems, and that the participants tended to have little or some knowledge of their legal rights. Or as Ani DeFranco sings, "If you don't understand, then how can you act?" It is the role of all legal professionals to act as zealous advocates in uncovering clients' entitlements. Suppose a client was alleging medical malpractice. Lawyers would not withhold asking questions about pain, injury, or lifestyle adaptations out of fear of false testimony. Therefore, failing to provide examples because of the potential for coaching is rooted in anti-survivor bias that favors the status quo. And further, it's misogynistic to suggest that women, trans, non-binary, and gender non-conforming people are uniquely susceptible to deception. This is from Jennifer Koshan, Challenging Myths and Stereotypes on Domestic Violence Cases, and Stephen Lubet's Modern Trial Advocacy, and Weekoff and Ellison's Evidence in Court, Witness Preparation and Cross-Examination Styles, and DeVern's Perceptions of Visibility on PLEI, if you wish to read further. Here are those citations. Thank you for taking the time to watch this video. I hope it was educational, and thank you again to the Community Legal Education Association for hosting this video, and I hope that legal professionals across the country can better support survivors.